Hello and welcome to our agency. Thank you so much for considering our business for your property management service needs. Please now sit back, relax and enjoy the presentation we're about to present to you. A handy tip is to have pen and paper ready just in case you have any specific questions as you view the presentation that you want to ask our property management team. Our agency pride ourselves on professionalism, ethics, compliance and risk management. This landlord presentation will set out landlord obligations generally by law, important information about your property and maintenance, also tenant obligations and so much more. Firstly, law sets out that landlords have an obligation to make sure their property is clean, fit for a tenant to live in good repair, and that the property complies with all relevant health and safety requirements set out in legislation. Landlords are required to disclose any material facts relevant to the property that may matter to the tenant. Whilst the law in Queensland is not black and white, general common law procedure is that disclosure should be made about matters relevant to a tenancy. Agents in Queensland have an obligation to be honest, fair and professional when dealing with tenants. Please refer to the landlord disclosure statement provided as part of our proposal for more information and required disclosures. We are required to carry out a title search upon listing your property for rent. The title search will only be at cost to you. An invoice will be provided and/or we can debit the funds from your rental statement. You'll also receive a copy of this title search, of course, for your records. Landlords in legislation have an obligation to ensure there is no legal impediment on the property. Now, examples of this include the property and structures are approved as required by relevant authorities. Another example is you may be required to notify your mortgagee that the property is a rental property. We understand tenant selection is one of the key factors of many that we have responsibility for as your managing agent. When assessing tenants suitable for your property or any of our investors' properties, two factors are taken into account. We look for proof and evidence that the tenants have ability to care for the property and also evidence that the tenants have ability to pay for the property. Now, these material facts are presented to you for your approval of the tenant that moves into your investment property. As you would be aware, there is legislation that sets out anti-discrimination laws. Legislation sets out matters that cannot be discriminated against in relation to tenancy. For example, it would be illegal to discriminate against a tenant because of their race, their religion, their marital status, or their parental status. Please refer to the information sheet on discrimination law and tenancy for more information if required. Of course, we are prohibited by law to accept any unlawful instructions from our client in relation to this matter. It is a legal requirement for landlords to have minimum smoke alarms in their property. Smoke alarms must be in working order at all times. We have contractors who can assist in the legislative obligations to ensure your compliance, safety and sound risk management. Please note also, it's a legal requirement for smoke alarms to be cleaned and tested within 30 days prior to a tenancy commencing, including a tenancy renewal. More information is available if you require from our agency. It is also a legal requirement for landlords in Queensland to have safety switches installed at their rental property. We recommend that the safety switch be tested on a scheduled basis to ensure safety plus sound risk management. Again, we have qualified electricians who can verify this for you and to also carry out the testing if required to make sure your property and your tenants are safe. The Building Act of Queensland is a relevant legislation for pool laws. Rental properties with pools cannot be let or re-let without a pool safety certificate. Please note your pool or spa for that matter must also be registered on the government website. Our agency can provide you with more information in this regard if required. As a landlord, of course, you have rights to accept pets at your property or not. If your property is a house with suitable fencing, we do recommend that you give consideration to allowing a pet at the property, as this type of property may attract people with pets, therefore broadening your options in the marketplace and making your property more appealing to many. Of course, we can have special conditions in the tenancy contract for pest control if required, which is quite common, and also to ensure that pets are outside only if that be your request. Tenants have obligations during the tenancy, such as keeping the premises clean during the tenancy, having regard to how they found it at the beginning. Ensure, of course, that they don't cause damage to the property. Don't use the property for an illegal purpose. Do not disturb the neighbourhood, and of course, pay their rent accordingly. We'll discuss rent in more detail shortly. If the tenant fails in any of these statutory obligations, breach notices can be served to them. We, as your agent, would carry out this service on your behalf as part of our management agreement, and of course, keep you informed at all times. The Tenancy Law of Queensland is covered under the Residential Tenancies Rooming Accommodation Act, the RTRA Act. In relation to entry to your rental property, the Act sets out reasons for entry to inspect. We, as one of the many services we carry out on your behalf, issue the statutory RTA Form 9 entry notice to the tenant. Landlords or their agents cannot visit property unless the correct form, required timeframe and reason for entry is valid. If an agent or landlord, lessor for that matter, does inspect without the above requirements having taken place, the tenants could issue the lessor agent with a breach notice for breaching the legislation. As one of the many services we carry out on your behalf, we carry out general routine inspections. This management service is carried out at least twice per year. They are generally completed by our agency every 4 months. However, please refer to the management agreement for further detail. We also carry out entry and exit inspections as required. The Act only allows general inspections to be carried out once every 3 months unless the tenant agrees to other inspections. When carrying out general routine inspections on your behalf, we will provide you with the best practice written visual report of the property. Of course, our agency are not builders, engineers, architects or any other type of profession. We cannot provide any other service during these inspections other than visual best practice advice. Further, in relation to routine inspections, the inspection report will advise any obvious or reported defects as reported by the tenants, maintenance, plus provide commentary as to how the tenant is maintaining your investment property. If any action is required, we'll request your written instruction or act according to the management agreement instructions. There are statutory obligations as well as common law for landlords to make sure their property is safe and maintained. The RTRA Act sets out the legislative definition of what is an emergency and what is a routine repair. Now please refer to Standard Term 30 of the Tenancy Agreement provided to you for the definition of what is an emergency repair and what is a routine repair. Section 185 of the RTRA Act requires that lessors maintain their properties and inclusions. Emergency repairs must be dealt with immediately and routine repairs within a reasonable timeframe. Please note, in relation to inclusions, any inclusions such as dishwashers, air conditioners, matters such as that are included have to by law be maintained. They cannot be as is. For example, if they break down, they cannot be fixed. Well, it has to be fixed by law. Should this occur during the tenancy, we of course will discuss this with you more if required. But also please note, if you have any concerns or reservations about maintaining any inclusions, it may be prudent to remove the inclusions if possible before renting your property out. Emergency repairs, as per Standard Term 30 of the said tenancy agreement previously, have to be done immediately. Now, we will contact you and advise you of the emergency and provide advice to you. In the absence of your instructions, such as we cannot reach you or it may be after hours, we shall always act in your best interest and attend to the repair, particularly in matters of possible or high risk, such as safety matters at your property. The tenant has a right under law to spend up to 2 weeks' rent when there's an emergency, but only if they've been unable to contact the lessor agent or the landlord has not authorised or responded and attended to the repair within a reasonable time frame. General risk management. Given, of course, the seriousness of maintenance matters, particularly when it comes to safety and security, it's imperative that we receive our landlord instructions promptly in writing. This requirement is subject to your instructions provided in the management agreement, of which we'll be asking for some authority to expend monies on your behalf. We have a statutory and contractual duty to always act in your best interest, which we promise to do. We also have a duty of care to the tenants. However, it can sometimes be difficult to assist investors with statutory requirements, as when a lessor restricts any authority. Please note, communication is the key, and we'll speak to you more about this during the presentation and during our management time should that be needed. Our role is to maximise your income and minimise your loss. You'll be advised via phone, SMS or email when maintenance has been reported or identified and what we are doing or have done. You will not find out at end of month when you receive your rental statement. In the litigious world that we live in, it's imperative that we all have sound risk management practices, which our agency prides itself on. Therefore, for general risk management reasons, we request prompt instructions if required, and also authority to expend monies to attend to required maintenance legislatively. The RTRA Act requires that tenants be provided with a key to every lockable door or device at your investment. The requirement is for one full set of keys to be given to the tenant, plus entry keys to any other named tenant to allow independent access. We also require a complete set of keys to be held in our office. Under the legislation, action can only be taken against a tenant who is behind in their rent when they are 7 clear days behind in their payment. Section 280 of the RTRA Act allows our agency on your behalf to serve a breach notice to the tenant on the 8th day. Under the relevant legislation, the tenant's then given the allowed remedy period, which is a further 7 days plus postage if required to pay the amount owing. We shall advise you promptly, of course, if rent defaults and keep you informed of all the developments until there's a successful outcome. If a tenant breaches the agreement, such as having unapproved pets or unapproved occupants or not keeping the premises clean, we will always act again in your best interest. In some cases, we may negotiate with the tenant to have the concern attended to promptly. In more serious cases, we'll issue an RTA Form 11 notice to remedy breach to the tenant, providing them the allowed remedy period to rectify the matter. We again, of course, will advise you, keep you informed until the matter is resolved. If your investment property does not have an individual water meter, water charges cannot be passed on to the tenant. If your property has an individual water meter, water charges can be passed on to the tenant. Our agency can provide you more information in this regard. The tenancy agreement is a legal binding contract between yourself and the tenant. We act on your behalf and complete and sign all the necessary paperwork to commence and continue a tenancy. Please note, we have provided an example of the General Tenancy Agreement as part of this proposal. The General Tenancy Agreement is legally referred to as the RTA Form 18A. There are 2 types of tenancy contracts in Queensland, a fixed term agreement or a periodic agreement. A fixed term agreement is a contract which has a definite start date and a definite end date. The tenancy, of course, can be renewed to another fixed term at the end should you choose to offer one to your tenant. However, the agreement does not automatically end on the end date. Required notices and timeframes or other action must be taken to end the tenancy lawfully. A periodic tenancy has a definite start date but not a definite end date. Required notices have to be given by either party to end either tenancy. The tenancy agreement, the RTA Form 18A, which again we provided to you as part of this proposal, has 44 standard terms which are the law and non-negotiable, and they must form part of every agreement in Queensland. Special terms are terms that are not standard terms, however, can be added to an agreement as long as they are lawful and do not contract outside of legislation. The Legal Profession Act of Queensland states that property agents cannot write or draft special terms or give advice. Only a lawyer or the lessor can write special terms. In saying that, we use special terms from our forms provider outlined in the example provided with the proposal. If you require additional special terms for your agreement, we will seek your written instruction. Of course, contracting outside the Act guidelines is prohibited. An example of contracting outside legislation is a request to insert a special term that an inclusion, such as a dishwasher, will not be maintained or replaced if it breaks down. This cannot be inserted due to the legislative provisions discussed earlier during the presentation under Section 185 of the RTRA Act. Generally, landlords are deemed responsible for maintenance of trees and high shrubs. If you require the tenant to maintain any particular matter of the garden a certain way, please provide a special term of your requirements to insert into the agreement. Regrettably, sometimes, of course, tenants may not look after your garden the way that you would if you were living there. It is recommended that high maintenance gardens be given consideration by the landlord in relation to future maintenance and water. For example, garden maintenance may be included as part of the property rent, and the rent to be adjusted accordingly so that the gardens are maintained to the standards you wish them to be. There are 7 ways a tenancy agreement can be terminated in Queensland. In brief, the 7 ways are covered under the RTRA Act, which are mutual agreement by you and the tenant at any time, tenant providing a notice of intention to leave, our agency, with your instruction, providing the tenant a notice to leave, abandonment, mortgagee in possession, death of a sole tenant, or an order of a tribunal. Please note that, of course, if the tenant is on a fixed term agreement, they are there for the duration of the agreement, unless all parties agree to mutually end early. If you wish, refer to Standard Term 7 of the General Tenancy Agreement provided in relation to what happens if a tenant wants to break their lease during the contract. Of course, should this ever occur, you'll always be informed and notified of what is occurring in that instance. Of course, regrettably, in tenancy situations, sometimes disputes occur. We, on your behalf, take the matter, if needed, to the RTA, which is the Residential Tenancies Authority, the government authority who helps the industry in relation to dispute resolution. Now, this only occurs, of course, once our own self-resolution attempts on your behalf have not been successful. Another avenue for tenancy disputes is tribunal. Should this ever eventuate, as your managing agent, we will, of course, again and as always, keep you informed and advise you at the time of the process, and we represent you as part of our services. We disperse rental funds at least once per month. If you choose, we can discuss with you the option of twice per month, mid-month and end of month. The disbursements are sent to your nominated bank account. We also provide a written statement demonstrating the income, expenses, fees and commissions with the total amount shown, of course, and GST is also on the statement as required by law. Our agency strongly recommends that you have landlord protection insurance. Whilst every action is taken to secure suitable tenants for your property, life changes such as job loss, marriage breakdowns and other social issues can sometimes lead to people acting outside their character. Sometimes, regrettably, as you would be aware, bad things happen to good people. But importantly, protect your investment, and for a relatively low cost that most likely is a tax deduction, landlord insurance is a must for today's investor. Public liability insurance is a must, and it's a contractual requirement under our management agreement that our landlords hold and maintain public liability insurance to no less than $10 million in value. We cannot begin managing your property until this information is provided to our agency. Public liability insurance, of course, is important for all of us to protect you and your investment. Also, we further recommend that, of course, appropriate building insurance is in place. If required, of course, seek your relevant inquiries to make sure your building and contents are covered. Please note that some items in your property may fall under contents insurance, therefore both building and contents insurance are, of course, strongly recommended. If your investment property has a body corporate, it's a legal requirement that tenants be given a copy of the bylaws when the agreement is given to them for signing. We will require a copy of the bylaws upon listing your property. It is recommended, where possible, that money be kept aside for maintenance and general upkeep of your investment. This will, of course, ensure your property is maintained in accordance with legislative obligations and for sound risk management. Well-maintained properties generally attract quality tenants and commonly long-time tenants as well. Of course, please refer to your accountant or advisor for more information should you require. Effective communication is one of the key ingredients to successful management. We pride ourselves on quality and professional services. Effective and sound communication is very important to us. Our agency preferred method of communication is email. As most instructions and communication are required to be in writing, you may wish to email us also. Please provide our agency with your preferred email address, your preferred contact numbers, of course, and a contact number of another person you designate in the event of an emergency and we cannot get in touch with you. Our agency complies fully with the federal privacy laws. All your personal details are protected and are in a safe, stored environment. If you have any concerns about your privacy, please contact our privacy officer or the agency licensee. Confidentiality is also assured and guaranteed. Please note it's a requirement that your full name is on the tenancy agreement, as the agreement is between yourself and the tenant. So the tenancy agreement will show your name, care of our agency. Also, the trust account receipts for when the tenant makes payment will also show your name as required by law. Our agency is unable by law to undertake any services for you as an investor until a written management agreement is in place. Thank you so much for viewing our landlord presentation. Please, if you have any further questions, phone the property manager, email, or whatever the best way for you to communicate is. Thank you very much, and we hope very soon to be working with you. Bye for now.